Welcome back for another kick-ass vlog in my McKenzie friend kick-ass series, and today in one manageable bite-sized chunk I will be explaining what a non-molestation order may actually look like. And even better, you can right now download a mock example of a non-molestation order. I am Philip Kedge, the kick-ass McKenzie friend, the director of the McKenzie Friend UK network, and I have been a McKenzie friend layperson for over a decade. And please note, nothing I say constitutes legal advice, because you don't need legal advice and you don't need lawyers in the family court. All the information that I give is as an informed friend. So let's do it. Sometimes one of the best ways to learn is to work backwards, and hence to understand non-molestation orders, one of the best ways to learn is to have an example in your hand. So take a pause here, go to contactphil.co.uk, click on the banner which takes you to all my kick-ass vlogs where you can download this mock-up non-molestation order. I call it a mock-up because it is an accurate example of what one may actually look like. How brilliant is that? So download it right now and come straight back. This fictitious non-molestation order is based on a scenario where the applicant has completed the form FL401 with a statement of evidence to apply for a non-molestation order, which is submitted on an urgent and without notice basis. An urgent and without notice application means that the respondent isn't aware that an application has been made, and a hearing is held without their knowledge, where the applicant is often seeking an interim non-molestation order. One of the main reasons why applications are submitted without notice is that it is feared that if the person is aware that an application has been made, that they will try and frustrate or stop it with intimidation and threats. In this scenario, a without notice hearing is held with only the applicant attending, where the judge has read the statement and agreed to grant an interim non-molestation order. So with that order now in hand, let's take a look at it. The first section tells the respondent that they have to obey this order. And if you don't, well, that is a criminal offence for which you can be arrested and on conviction fined or imprisoned. Be in no doubt, these orders pack a punch. Do not breach them. Let's have a read. In the first part it says, important notice to the respondent, with their name and date of birth inserted here. You must obey this order. You should read it carefully. If you do not understand anything in this order, you should go to a solicitor, legal advice centre or citizens advice bureau. You have the right to apply to change or cancel the order. In the second part, it states, if without reasonable excuse you do anything which you are forbidden from doing by this order, you will be committing a criminal offence and liable on conviction to a term of imprisonment not exceeding 5 years, or to a fine, or to both. Alternatively, if you do not obey this order, you will be guilty of contempt of court and may be sent to prison. Next, it lists when the hearing took place and the name of the judge, and here it explains on the date of the hearing, with the name of the district judge also inserted here, sitting at the family court, which will be stated, considered an application for an order. The applicant was in attendance with their McKenzie friend, who will be named, a member of the McKenzie Friend UK network. The respondent had no notice of the application. The court read the witness statement of the applicant. This order is made in the absence of the respondent. The court has considered only the evidence of the applicant. The court has made no findings of fact. The court had regard to section 45(1) and 2 of the Family Law Act 1996. Next is an explanation as to why the order has been made. The court decided to make an order without notice to the respondent, having had regard to all the circumstances, including any risk of significant harm to the applicant or a relevant child attributed to the conduct of the respondent, if the order is not made immediately. It is likely that the applicant will be deterred or prevented from pursuing the application if an order is not made immediately. And now to the meat on the bone, the order itself. You can have various different orders and restrictions, and this represents only an example of a few. So let's take a look. It is ordered that the respondent must not, whether acting on his or her own or jointly with another person, use or threaten violence against the applicant, intimidate, harass, pester, threaten or verbally abuse the applicant in any way, send any threatening or abusive letters, emails, texts or voicemail messages to the applicant, make any threatening or abusive telephone calls to the applicant, destroy or damage or threaten to destroy or damage any property owned by or in the possession and control of the applicant, go to, enter or attempt to enter the home address of, and the address will be inserted here, and must not go within 100 metres of it. Instruct, encourage or in any way suggest that any other person should do anything which the respondent must not do by the terms of this order. Let's now move on to the further sections of the actual order. These are still orders, but a little bit more admin related. The non-molestation order shall be effective against the respondent once he is made aware of the terms of the order, whether by personal service or otherwise. This order remains in force until the matter is brought back to the court at the next hearing. The case will be heard by a district judge. The court will reconsider the application at a further hearing on the date and time being entered here. Estimated time for the hearing is 1 hour. The next hearing will be held in person at the name of the family court will be inserted. If any party does not attend the hearing, the court may make orders or final orders in their absence. To continue, the following special measures shall be in place for the hearing. Privacy screens will be used in court and the applicant shall be provided with a separate waiting room. The applicant may contact the court to request any further special measures to avoid coming into contact with the respondent at the court. The respondent must send to the court and the applicant any written evidence on which the respondent intends to rely on at least 48 hours before the hearing. This order must be personally served on the respondent. The applicant should not themselves attempt to serve the respondent directly. In the event that the applicant cannot arrange for a process server or effect service through a third party, the applicant should apply for a bailiff service. The statement of service must be sent to the court at least 48 hours prior to the next hearing. The costs of the application are reserved. Which now brings us to the conclusion of the order. Until further order, this order is made without notice to the respondent. Note to the arresting officer. Under Section 42A of the Family Law Act 1996, a breach of a non-molestation order is a criminal offence punishable by up to 5 years imprisonment. It is an arrestable offence and it is not necessary to obtain a warrant. A person who without reasonable excuse does anything that he is prohibited from doing by a non-molestation order is guilty of an offence. Family Law Act 1996, Section 42A1. So that's it, folks. Knowledge is power, and a great starting point is to understand what a non-molestation order may look like as a training tool. If you would like a one-to-one case review with myself on any aspect of your family court case, or you would like to speak to one of our brilliant independent McKenzie friends, then just contact me at contactphil.co.uk. Until next time.